first question is, the rule of unanimity contained in the section 12 clause C of the Indian Partnership Act 1932 has a reference to which of the following? Options are A. Fundamental matters, B. Ordinary matters, C. Trivial matters, or D. All of the above. The correct answer to this question is option D, that is all of the above. That is, the rule of unanimity contained in section 12 clause C of the Indian Partnership Act has a reference to fundamental matters, ordinary matters, and trivial matters. The next question is, an agreement to carry on business in partnership in future create a partnership of which nature? The options are A. Are immediately on the agreement, B. Are on the date mentioned in the agreement irrespective of whether the business has commenced or not on that date, C. Only on the date when the business is actually commenced, or D. Never creates a partnership and any such agreement is void. The correct answer to this question is option D, that is, an agreement to carry on business in partnership in future never creates a partnership, and any such agreement of future partnership is void. The next question is, whether a partnership exists or not is a question of what nature? The options are A. Question of fact, B. Question of law, C. Mixed question of fact and law, or D. Either A or C. The correct answer to this question is option A, that is, whether a partnership exists or not is a question of fact. The next question is, the maxim socii means socii, mu socius non est means which of the following? Options are A. My partner's partner is not necessarily my partner, B. My partner's partner is necessarily my partner, C. The partnership has become illegal, or D. The partnership stands dissolved by the act of God. The correct answer to this question is option E, that is, this maxim means that my partner's partner is not necessarily my partner. Number of person required. The next question is options are A. 2 members, B. 5 members, C. 10 members, or D. 20 members. The correct answer to this question is option D, option A. That means the minimum number of persons required for creating a partnership is 2 members. The next question is the maximum. The maximum number of partners in a partnership has been provided under which of the following acts? The options are A. The Indian Partnership Act 1932, B. The Indian Companies Act 1956, C. The Indian Contract Act 1872, or D. The Indian Trust Act 1882. The correct answer to this question is option B, that is, the Indian Companies Act 1956 provides the maximum number of partners in a partnership firm. The next question is, under Section 11 of the Indian Companies Act 1956 for non-banking business, the minimum number of partners can be, options are A. 10 members, B. 20 members, C. 25 members, or D. 30 members. The correct answer to this question is option B, that is, the maximum number or the minimum number of partners under Section 11 of the Indian Companies Act for non-banking business can be 20 members. Next question is, for a banking business, the maximum number of partners in a partnership under Section 11 of the Indian Companies Act 1956 can be option R, A, 10 members, B, 15 members, C, 20 members, or D, 25 members. The correct answer to this question is option A, that is, for a banking business, the maximum number of partners in a partnership firm under Section 11 of the Indian Companies Act can be 10 members. The next question is, where a partner is entitled to interest on the capital subscribed, such interest is payable. Options are A, out of profits only, B, out of capital if no profits, C, out of capital if losses, or D, either A or B or C. The correct answer to this question is option A, that is, a partner is entitled to interest on capital subscribed out of profits only. The next question is, Section 13 Clause A of the Indian Partnership Act provides for options are A, payment of remuneration to a partner as a matter of right, B, payment of remuneration to a partner only when there is an agreement to that effect between the partners, C, non-payment of the remuneration to a partner only when there is an agreement to that effect between the parties, or D, both A and C. The correct answer to this question is option C, that is, non-payment of the remuneration to a partner only when there is an agreement to that effect between the parties. The next question is, under Section 13 Clause B of the Indian Partnership Act 1932, all the partners are entitled to which of the following? Options are A, share the profits and losses in the ratio of their capital contributions, B, share the profits and the losses equally irrespective of any agreement between them to the contrary, C, share the profits and the losses equally in the absence of any agreement to the contrary between them, or D, share the profits and the losses in the ratio of their personal efforts input. The correct answer to this question is option B, that is, the partners share the profits and the losses equally irrespective of any agreement between them to the contrary. The next question is, where a change occurs in the constitution of a firm and no new agreement is made, which of the following then is correct? Options are A, the ratio of the profit sharing shall become equal for all the partners, B, the ratio of the profit sharing shall remain same to the extent to which it is consistent with the altered composition of the firm, the ratio of the profit sharing shall change the ratio of the capital contribution, D, the ratio of the profit sharing shall change the ratio of the personal efforts, labor input of the partners. The correct answer to this question is option B, that is, where a change occurs in the constitution of a firm and no new agreement is made, then the ratio of the profit sharing shall remain same to the extent to which it is consistent with the altered composition of the firm. Is, as a general rule, by the virtue of Section 13 of the Indian Partnership Act 1932, which of the following is correct? Options are A, partner is not entitled to interest on the capital subscribed by him, B, the partner is not entitled to interest on the advance made over and above the share capital, C, both A and B, or D, neither A nor B. The correct answer to this question is option D, that is, neither A nor B. That is, by the virtue of Section 13 of the Indian Partnership Act, neither a partner is not entitled to interest on the capital subscribed by him, nor a partner is not entitled to interest on the advance made over and above the share capital. The next question is, as regards the capital contribution in the partnership business, the status of a partner is that of which of the following? Options are A creditor of a firm, B, a partner of a firm, C, an employee of the firm, or D, all of the above. The correct answer to this question is option B, that is, the status of a partner shall be that of a partner of a firm. The next question is, the status of a partner making advances to the firm for its business over and above the capital subscribed is that of. Options are A, a partner of a firm, B, a creditor of the firm, C, an employee of the firm, or D, both A and B. The correct answer to this question is option A, that is, the status of a partner is that of a partner of a firm. Next question is ordinary on the overdrawing by the partner from the firm. Which of the options are correct? Options are A, no interest is chargeable, B, interest is chargeable at the rate 6% per annum, C, interest is chargeable at the rate 9% per annum, or D, the interest is chargeable at 12% per annum. The correct answer to this question is option B, that is, an interest is chargeable at 6% per annum if there is an overdrawing by a partner from the firm. The next question is, a partner has a right to indemnity for the act done in which of the following? Options are E, ordinary and a proper conduct of the business, B, an emergency, C, both A and B, or D, only B and not E. The correct answer to this question is option C, that is, in both cases, that is, in the ordinary and a proper conduct of a business and during an emergency, a partner has a right to indemnity from the act done. The next question is, the right to indemnity is lost on which of the following? Options are A, the dissolution of the firm, B, the death of a partner, C, the retirement of a partner, or D, neither A nor B nor C. The correct answer to this question is option D, that is, neither A nor B nor C.